Hello, my name is Devon Overton, and today I'm going to talk to you about the recent Supreme Court decision that ruled that it is not considered racial discrimination to ban dreadlocks in the workplace. Some people are very upset about this. They're in a social uproar. They are convinced that it is racial discrimination, while others believe it is perfectly acceptable within a company's grooming policy to rule out certain hairstyles as unprofessional. This ruling allows employers to refuse to hire individuals if they have dreadlocks, or they can request that they cut them in order to gain employment. The court concluded that hairstyles are a choice. Therefore, they're not an immutable physical characteristic, while acknowledging that hairstyles could be culturally associated with race. Data, research, and former rulings um, indicate that the United States courts and rulings are historically biased and lack inclusion uh, when they reach initial rulings as they relate to race relations and cultural relations within this country. They have also historically corrected these bias in later rulings. I'm going to start by providing some history on dreadlocks and black hair in the workplace. A dreadlock is defined in Webster's dictionary as a narrow rope-like strand of hair formed by matting or braiding. Dreadlocks have a spiritual background in many cultures and are considered a beauty and cultural staple amongst African American people. Many people argue that dreadlocks would naturally form in what is considered traditionally to be African American hair texture. Um, there have been many grievances related to employers and schools and the dictation of hairstyles that are permitted. Oftentimes, the rules and restrictions set forth by grooming policies are seen as specifically targeting or singling out African American or Black people because they restrict hairstyles that are worn in particular by people with textured or curly hair. Oftentimes, these hairstyles protect hair and encourage healthy hair and are not just merely hairstyles. America is also known for encouraging integration amongst people with different backgrounds and cultures in the past. In many cases of integration, if it's not accepted or widely accepted by a group of people, assimilation is then forced upon the people, as has been the case for Native Americans, African Americans, and many other cultures throughout the U.S. history. Many people see this case as yet another form of assimilation. Particularly minorities feel this way, while others think it is just a fact of life or that certain hairstyles are just not considered appropriate for the workplace. Huge legal strides have been made in an effort to protect minorities in the workplace. The Equal Employment Opportunity Commission, also known as the EEOC, has taken huge legal strides since their formation in 1965 to help enforce the Civil Rights Act of 1964. They took on this case in particular in hopes of providing the denial or proving that the denial of this job offer because of dreadlocks was in fact a form of racial discrimination. The Court of Appeals for the 11th Circuit, EEOC versus Catastrophe Management Solutions was the name of the company. The court argued that in this case, the grooming policy was race neutral and that any race could have or would have been denied employment had they refused to remove their dreadlocks. The court also argued that a hairstyle is a choice and is a mutable characteristic, even if it is more closely associated with a particular ethnic group. In the past, the Supreme Court has ruled against culturally or religious motivated discrimination cases where employees were forbidden to wear spiritual headgear or asked to cut or shave their hair, even when their hair had religious significance. These rulings aim to protect individuals from discrimination in the workplace based on protected attributes in relation to the individual or a group of people. employers have the right to implement grooming standards that do not discriminate against attributes of people that are protected by the Civil Rights Act. In this case, the court found that the company did not discriminate against the employee based on the any protected attributes. Some find it surprising, though, that the court did not rule in favor of the EEOC. According to the logic used by the court, some felt that they could ban other hairstyles such as afros, which are natural occurrences in black hair, where others felt like that would be obvious discrimination against actual hair of many African Americans. Grooming policies can be customized by a business. This issue comes in. The issue comes in when grooming standards are considered considered different by definition and specific amongst different cultures. Many questions may arise in the future about what is an acceptable request and what is not. I think this opens up a important conversation, and I think the government and the Supreme Court definitely have work to do from here on out to ensure that everyone is treated fairly and equally.